Welcome everyone to our webinar on navigating commercial property disputes, resolving common conflicts. My name is Paul and I'm a Senior Associate in LegalVision's leasing team. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email. Submit your questions in the Q&A box and we'll answer them at the end. Please complete the feedback survey after the webinar. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today we'll be discussing rent, service charges, repairs, dilapidations, and the Landlord Tenant Act 1954. At the end of the webinar, we'll be answering some of your questions. So please submit your questions throughout the webinar through the chat function and we'll answer them at the end. Firstly, let's look at rent and rent increases. The obligation to pay rent is an absolute obligation. If you don't pay your rent, it will have serious consequences. One of these is that it may allow your landlord to terminate your lease and take back possession of the property. And they can do this without going to court first. This action is called forfeiture, and doing it without a court order is called peaceable re-entry. A landlord can engage a bailiff to change the locks at night. Where a landlord can terminate for this reason, tenants often mistakenly believe that the landlord needs to demand the rent first, for example, by issuing an invoice. This is not the case. Almost all modern leases will permit the landlord to terminate irrespective of whether a notice or demand is given. Usually, the only requirement is that a certain number of days have elapsed since the rent was due. If your lease has been forfeited and you want to stay in the property, you'll either need to go to court or negotiate a new lease. If you go to court, you are seeking a remedy called relief against forfeiture. The court doesn't have to make this order, but if the issue is non-payment, then they usually will if you agree to pay the arrears, interest, and the landlord's costs. A lot of landlords do get forfeiture wrong, so if there's a misunderstanding about rent, but you're willing to pay it and forfeiture has happened anyway, we recommend speaking to a lawyer. It is also a common misconception that tenants have the right to deduct or set off from their rent. For example, when the landlord has not carried out certain obligations, like repairs. In fact, the rent can only be reduced or suspended where there is a contractual or legal right not to pay it. For most tenants, this will be limited to situations of insured damage. In most other situations, tenants need to be wary of stopping payments, or they may give the landlord rights to forfeit the lease or use the commercial rent arrears recovery process. That process allows landlords to use enforcement agents to sell the tenant's business property where their debts are not paid within 7 days. Therefore, if you have a situation where the landlord is not performing an obligation that it is obliged to, it is best to look at the terms of the lease and see what the landlord ought to be doing and how you enforce that before you decide to stop paying rent. Issues stemming from non-payment is one thing, but another common area for disputes is when the rent needs to be reviewed. Let's look at that now. There are some common forms of rent review. The most common are an open market review. This is where a hypothetical lease is used to get a market rent amount. The key thing to note is that a market review is usually an upwards only review, which means the rent will either increase or stay the same. An increase is often an uncapped increase. An index-linked review is tied to a specific index, for example, the Retail Properties Index. Again, these are usually drafted to simply align with the index and increase accordingly. They are not often capped. A stepped increase or fixed percentage increase. These are less common, but offer more cost certainty. These rarely engender disputes, though, as the rent and frequency of the increase were agreed up front. A word to look out for is compounding, because this will act as though the increase has happened each year leading to the review date. Disputes under review mechanisms generally centre on an unfavourable and high increase or a late review with a backdated increase. It's always a good idea to try and negotiate some form of cap on the rent review. Where a review is uncapped, It can result in a very high increase, and tenants often have little scope to challenge this. But if you're stuck with an upwards only clause and you receive a proposed rent from the landlord that is high, what can you do about it? Firstly, most review provisions will allow the parties to agree the rent, so you can try and negotiate with the landlord commercially. If you can't agree, you need to see what your lease says about having the rent determined by someone else, usually a surveyor. The risk of having a surveyor assess the rent is that you probably don't know what the market actually is, remembering that the hypothetical lease assessment is how this will be determined. A surveyor may come back with an even higher increase. Exercise caution, but if you're in a stalemate with the landlord, this may be necessary. You could engage your own surveyor to assess it first. We often get asked whether the landlord can complete the review late. In most leases, yes. Normally, the landlord will not be obliged to do a review on time. So to avoid issues, it is actually better for tenants to be making sure the reviews happen when they should. And can the landlord then backdate the increase? Again, yes. Most leases will also state this directly. Not only this, but the landlord may even be able to charge interest on the shortfall amount, which is an incredibly common provision. Therefore, a lack of review won't be a free ride. A backdated increase can cripple tenants financially, leading to forfeiture issues. The next area that we'll look at is service charges. A service charge is expenditure that a landlord makes for areas that aren't let to tenants, but are used by them in common. If you have a lease over everything the landlord owns, then you're unlikely to have service charge provisions. But if what you are leasing is only a portion, your lease will most likely contain some form of service charge. Your proportion will usually be what's called a fair proportion, but in reality, this normally reflects the percentage for which your lettable floor area bears to the remaining areas of the building. A good service charge clause will state that the services that can apply and the charging processes in great detail. Sometimes tenants will manage to cap their liability for service charges by capping the amount they can be charged, for example, only paying £1 per square foot. Doing this avoids disputes, and often tenants with a cap won't worry too much about the service charges, provided the cap is being applied properly. A lot of provisions, though, are uncapped, and this is inevitably where disputes occur. An immediate issue for tenants faced with a comprehensive service charge regime is that landlords very rarely agree to amend the provisions, even if they're not standard. There is a simple reason for this. They can't have different service charge regimes for different tenants within their estate because it would make the calculations far more difficult, and a lot of other metrics are based on the service charge provisions, like market rents. In these situations, a cap is really the only negotiation option. Other tenants may have a very poorly drafted service charge regime that is applied ad hoc, and here it is important to know how they expect these to be on-charged. Often this will be payable on demand, as and when the specific charge is incurred, which can be problematic where this is expensive. An issue that impacts both of these scenarios is who is making the assessment. Most larger landlords will use a surveyor who is generally impartial and RIC certified. But if this isn't the case and the landlord itself is assessing the costs without oversight, and this can't be challenged, disputes over charges quickly arise. Service charges should generally cover maintenance, repair and decoration of all common parts. For example, this can include car parks, lifts, lobbies, and external or structural elements. It can also include the staffing and administration costs for this, such as security personnel, managing agents, etc. Service charges should, however, contain exclusions, which might include costs other tenants are responsible for, certain capital replacements, like adding to or rebuilding the fabric of the building, matters that really just relate to the landlord, like taxes and reletting costs, or matters covered by the landlord's insurance. For payment of the service charge, a good regime will be structured so that the tenant pays at recurring intervals on the basis of an estimate for the year. That estimate is then reconciled at the end of the year, and a tenant either pays more or is credited for the next year. Payment of the service charge can be as important as payment of the rent, so tenants should not treat it any differently. In fact, service charge regimes do quite often get pulled into forfeiture rights, so it can be a reason for the landlord to forfeit. The starting point for any tenant who isn't entirely sure how their service charge regime works will be to review the part of the lease that talks about it in detail. If there is a dispute about calculations, many clauses will allow matters to be referred to an independent expert, which can be a useful tool to force the issue if a discussion hasn't worked. Now let's look at repairs. There are a lot of misunderstandings about repairing obligations in commercial leases. As a tenant, it is important to know what you need to repair. Repair obligations start with the boundary of the premises. The boundary will be defined by a combination of a definition and a boundary shown on a plan. You will want the definition to say that structural, external, and load-bearing parts are excluded. However, it's very common for the definition to be drafted poorly, making tenants responsible for structural parts of the property. Once the boundaries of the premises are known, you apply this boundary to the words in the repairing obligation. A repairing obligation will usually say something like, the tenant will keep the premises in good and substantial repair and condition. Practically, this means that anything in disrepair within the boundary you are responsible for must be repaired by you. This includes any pre-existing disrepair. There are two general qualifications to this. One, tenants are not generally required to improve the landlord's property. And two, repairing obligations are interpreted according to the age, character, and location of the property at the time the lease was entered into. As to the acronym FRI, this just means full repairing and insuring, which means that the tenant is responsible in full for repairing the premises and paying the landlord's insurance. Be wary of these acronyms. Ultimately, you just want to be responsible for internals if possible. Repairing covenants can be limited. Here are a few common methods: limiting the boundary to internal areas only, reducing the repairing obligation to just keeping the premises in good repair, anchoring the repair obligation to a schedule of condition, which we'll talk about in a moment, or excluding risks that the landlord is insured for. A schedule of condition is a photographic schedule that notes the existing state of repair of a property. If a schedule is used, then the tenant will not be obliged to put the premises in any better state of repair or condition than that shown in the schedule. While this is a great limit on risk, schedules are not bulletproof and they have some obvious flaws, including: 1, they may not include key parts of the property. 2, they can produce a repairing gap where you might not need to repair an item, but neither does the landlord. And 3, they often don't limit decoration obligations. Decoration, then, is often a separate obligation in the lease to paint and paper the premises at either specific intervals or, whenever necessary, and at the end of the term. These obligations are rarely qualified, so you may inevitably have a situation where the decoration obligations override the restriction intended by the schedule of condition. But what rights does a landlord have if you don't comply with your repairing obligations during the term? The most basic right a landlord has is to do the repairs itself, and claim the cost from you. Repair disputes, though, often arise among other issues, and what we see often is a tenant withholding something because it believes a landlord is obliged to fix a problem. For example, the rent. As we discussed earlier, this can have a bad consequence for tenants. It may also not actually force the landlord's hand in rectifying a repair issue. To mitigate repair risks, we suggest thoroughly inspecting the premises before the lease and negotiate the requirements to limit obligations. If you're having a repairs disagreement and the issue does fall on the landlord, then you should ensure that you've followed any requirements in the lease to properly notify the landlord of the issue and keep paying the amounts that you're required to pay. This way you maintain your own compliance with the lease while you continue to negotiate or obtain external advice on how to compel the landlord to comply with their obligations. Connected to repairs is the area of dilapidations, which can be a major area of risk for many tenants, and that's what we'll turn to now. Dilapidations are items of repair that you were obliged to carry out but didn't. They are typically documented by a surveyor in an industry-recognised format. They can either be served during or after the term, most commonly after the term. Dilapidations risk most often arises with end-of-term obligations not being complied with. Often these obligations are explicit within the lease and will normally require 1, that the premises are handed back, having complied with the repairing and decorating obligations, 2, that the tenant has removed signage and loose property, and 3, in many cases, some form of reversal and reinstatement, typically stripping out the fit-out and making good. Where a tenant doesn't do this, the landlord has a good claim for dilapidations, and these claims can be substantial. There can also be interplay between the lease and a license for alterations. Sometimes these won't have been drafted in a consistent way, and the reinstatement obligations become confused or more onerous than the parties may have originally intended. Claims for dilapidations will normally start with a surveyor's schedule, but they quickly become complex and do go to court. If you receive a dilapidations claim, it will be important to take it seriously, as normally, if it has been served correctly, you will have 56 days to respond. If you don't, and it goes to court, there can be penalties for non-compliance with the dilapidations protocol. Responding to a claim for dilapidations as a tenant will often mean engaging both a lawyer and surveyor and potentially a valuer. A landlord is often not limited to only claiming the dilapidations. They will also seek to recover lost rent and various professional fees. It won't matter if the agent accepted the keys at the end of the lease, you may still find yourself in receipt of a dilapidations claim. So don't take shortcuts with the end of term obligations. It can backfire considerably. The best way to mitigate dilapidations risk is thorough due diligence on the property before you sign the lease, and this includes having the repairing obligations reviewed. If you're already in the lease and are concerned about the risk, review the provisions now so you can start planning for the future. This will allow you to determine the strategy and potentially start some repairs or reinstatement work earlier. If you have reinstatement obligations, initiate discussions with the landlord about them early to come to a decision that suits both parties. You can agree to a dilapidation settlement agreement to ensure you can walk away at the end of the lease without the risk of a claim on those issues. If you're already experiencing a dispute, a good surveyor will be essential, and it's always worth remembering that these disputes can be settled out of court. Now we're going to turn to the Landlord Tenant Act, 1954. So let's look at the security of tenure rights for business tenants. Under the Landlord and Tenant Act 1954, certain business tenancies acquire special rights. We'll look at the main two. First is that the lease will not end at the end of the term, but will be continued by the Act. Second is that the tenant will be entitled to a renewal of the lease. The landlord must agree to a renewal unless it can oppose renewal under the Act. Broadly, the Act applies based on the type of occupancy right, that is a lease greater than 6 months in length with an identifiable term, and the nature of the occupancy, that is most businesses. Importantly, a tenancy at will or a license agreement will not have security of tenure, but a periodic tenancy will. Where a business tenancy is continuing because of the Act, both the landlord and the tenant need to serve specific notices to be able to either oppose renewal in the case of the landlord or request renewal in the case of the tenant, or to end the tenancy altogether. The landlord needs to serve what is called a Section 25 notice, setting out the grounds upon which they are opposing renewal. The tenant would need to serve what's called a Section 26 notice, setting out the proposed terms of their renewal lease. Importantly, once one party has served one of these, the other cannot be served. So if the landlord has served a Section 25, that is what the parties need to deal with. The tenant can't then serve a Section 26. If the landlord is opposing, then it has to provide a termination date that is between 6 months and 12 months after the date of the notice. This can't be earlier than the end date of the tenancy, but it can be the same date. The tenant then has to either resolve the situation with the landlord directly or go to court to challenge the opposition. There are 7 grounds of opposition set out under the Act. The most common of these are the first 3, which relate to various breaches, being lack of repair, persistent delays in paying rent, or material breach of obligations. The landlord intending to occupy the property for its own business, or the landlord intending to demolish or reconstruct the property. As mentioned, these can be challenged in court. For example, under a redevelopment ground, the intention to redevelopment has to be genuine rather than speculative. The landlord can't just use the Act as a means to evict a secured tenant. The landlord may also be liable to pay you compensation under certain grounds. While security under the Act is great, it has become an unfortunate reality that the majority of commercial leases these days are actually contracted out of the Act, which is entirely possible and legal. To contract out, the lease must contain a specific form of clause pointing to the fact that the landlord followed a specific process prior to the grant of the lease. If this all happens the way it is required to, then the tenant will have no security of tenure, and the lease will end on the end date without rights of renewal. Many tenants don't actually know that they have a secured tenancy and therefore accept landlord positions at the end of their lease, believing that they have limited rights. In fact, your lease might be protected and the landlord might have little basis to be pushing you into a new lease that you don't agree with or instead threatening to evict you. If this is your scenario, check the lease. Does it contain a clause referring to Section 38A of the Landlord and Tenant Act? And did you complete a declaration before you entered into it? If not, then perhaps you have a secured tenancy. Arguments also arise over the terms of the new tenancy, which can be made by agreement. You don't need to go to court if the parties can resolve the issue. It's important to remember that if you are secured, you can ultimately have the court determine the terms. If you have a secured tenancy, then it becomes a strategic consideration as to what you do when you're approaching the end of the term. If you're on good terms with your landlord, then you might have a good idea of whether they will be offering a new tenancy on reasonable terms. If things have been rocky, then you may need to give thought about the grounds of opposition and whether there are signs the landlord might oppose your renewal. Consider these matters before the end of the term. You don't necessarily need to raise these with the landlord right away, but half the battle is understanding your rights. Of course, if you are a secured tenant, then you can also just let the lease roll over, but you risk the landlord serving a Section 25 notice. If you have a contracted out lease, the best approach will be to determine what the landlord is planning well before the end of the term. This will help you manage cost and risk if you do need to relocate. A rushed relocation can be disastrous for tenants who are then forced to accept an even worse tenancy the next time round. That concludes the main part of our webinar. You might find our publication useful, the Landlord's Cheat Sheet for UK leasing terms. We also have an upcoming webinar that might be of interest to you. That's how to prevent and manage a data breach in your business on Tuesday, the 8th of October at 11 a.m. We're going to answer your questions shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all your business's usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business's usual legal work so you can focus on running your business. To learn more about how membership can help you, request a free consultation when the survey appears at the end of this webinar. And now we'll answer some of your questions. So we had One question here was, can the rent increase while a lease is continuing under the 1954 Act? The answer is yes, the rent can increase. There can be interim rent increases. Essentially, if the lease is continuing under the Act, it's almost treated like the lease carries on the same terms. So there can be increases brought into those terms. Sometimes if there is a contracted in lease, landlords will be clever about this and they'll actually position a rent review to be on the final day of the term. And that is for this exact reason. The next question we have is, can you argue that you're only liable for internal parts if your lease doesn't say anything is excluded? That's a good question. So it becomes a matter of fact about how the terms of the lease should be applied, but you can make certain arguments that things ought to be excluded or that you might have only had an internal lease. This becomes a question of, does your lease say anything about obligations the landlord might have for different areas of the property? Is there an obligation that they keep the structure in good repair and condition, for example? Are there service charge provisions that would make it unreasonable to assume that you're liable for areas that are structural if they're being covered by the service charges? These are all things that would be considered if there was a dispute on those issues. So the short answer is you can definitely try and make the argument. And the final question that we have is, can a landlord serve a dilapidation schedule before the end of the term? They can serve a dilapidation schedule before the end of the term. What sometimes happens is they might use that as a way of negotiating the end of term obligations. And quite often, what the protocol will require in that situation is they will send probably an unsigned, not finalized version of the schedule. And then at the end of the term, they'll need to do the inspection again and then issue a final version of the schedule, which will be signed off by their surveyor and them. Just check if we had any other questions come through. Doesn't look like we've had any other questions. So that's all the time we have for today then. After the webinar ends, a survey will pop up. We would really appreciate it if you could complete the 30-second survey. Please include your contact details to receive a complimentary legal consultation to discuss how we can help you with your commercial lease. Thanks so much for joining us.